A federal court decision came down last week that changed 10 major gun laws across multiple states, and the mainstream media is completely ignoring it. If you own guns, carry concealed, or have been prohibited from exercising Second Amendment rights because of restrictive state laws, what I'm about to reveal could immediately expand your gun rights. Hit that subscribe button because this court ruling affects gun owners in 23 states, and unless you're following firearms litigation closely, you probably have no idea these changes just happened. Here's what happened. On April 8th, 2026, the Fourth Circuit Court of Appeals issued a consolidated decision in 6 cases challenging various state gun laws. The 3-judge panel applied the Supreme Court's Bruen framework and struck down provisions affecting 10 major categories of gun regulations. The decision is binding in Maryland, Virginia, West Virginia, North Carolina, and South Carolina, with legal experts predicting similar challenges will succeed in other circuits. Let me break down all 10 gun laws that just changed, which states are affected, what this means for your gun rights, and what you need to do right now to take advantage of these newly recognized freedoms. Number 1, magazine capacity limits are now unconstitutional in the Fourth Circuit. Maryland's 10-round magazine limit was struck down as violating the Second Amendment. The court held that standard capacity magazines, typically 15 to 30 rounds, are in common use for lawful purposes and cannot be banned. This doesn't just affect Maryland. It creates precedent for challenges in every state with magazine capacity restrictions. California, New York, New Jersey, Connecticut, Massachusetts, Colorado, and others with mag limits are now vulnerable. Gun rights groups are already filing new lawsuits citing this Fourth Circuit decision. For Maryland residents, this means you can now legally purchase and possess standard capacity magazines. The 10-round limit cannot be enforced. Retailers in Maryland are scrambling to stock 15, 17, and 30-round magazines that have been prohibited for years. Number 2, good cause requirements for concealed carry permits are dead in the affected states. Virginia and Maryland both had discretionary permit systems where you needed to show good and substantial reason to get a carry permit. The court ruled these subjective standards violate the Second Amendment. This follows the Supreme Court's Bruen decision, but many states tried to maintain similar requirements under different names. This Fourth Circuit decision makes it crystal clear. States cannot require applicants to justify their need for self-defense. The right to carry is presumed, not contingentally granted. If you've been denied a carry permit in Maryland, Virginia, West Virginia, North Carolina, or South Carolina because you couldn't prove good cause, you can now reapply under shall issue standards. As long as you pass the background check and meet objective requirements, the state must issue your permit. Number 3, waiting periods longer than 72 hours are now unconstitutional. Several states in the Fourth Circuit had waiting periods of 7 to 10 days for firearm purchases. The court held that while a brief waiting period for background checks is permissible, extended delays that serve no legitimate purpose beyond inconvenience violate the Second Amendment. The decision caps waiting periods at 72 hours. If the background check can be completed faster, the firearm must be released immediately. If the background check cannot be completed within 72 hours, the transfer must proceed by default unless law enforcement has specific evidence of disqualification. This affects Maryland's 7-day waiting period and similar laws. Gun stores can now release firearms after 72 hours, even if the state tries to impose longer waits. If you're finding this helpful, imagine what you'll learn in my next video where I reveal the 3 states about to copy this court decision and expand gun rights even further. Subscribe now so you don't miss it. Number 4, gun-free school zones are now limited to the actual school property. Federal and state laws created gun-free zones extending 1,000 feet from school property, effectively making large portions of towns and cities off limits for legal carry. The court struck down these extended zones as overbroad. The ruling allows states to prohibit firearms on actual school grounds and inside school buildings, but not in the surrounding public areas. If you have a valid carry permit, you can now legally carry in areas near schools that were previously prohibited. This is huge for urban gun owners. In many cities, the overlapping school zones made it nearly impossible to carry legally anywhere. That restriction is now gone in the Fourth Circuit states. Number 5, mandatory firearm training requirements for carry permits were declared unconstitutional. While states can offer training and encourage it, they cannot mandate specific training courses as a prerequisite for exercising Second Amendment rights. The court compared firearm training mandates to literacy tests for voting. Both involve important skills, but the government cannot condition a constitutional right on completing government-approved training. This strikes down training requirements in Maryland, North Carolina, and similar provisions in other states. If you've been unable to get a carry permit because you couldn't afford the required training course or couldn't find available classes, that barrier just disappeared. Quick legal note. This is educational information about the Fourth Circuit Court of Appeals decision and its impact on state gun laws. This is not legal advice for your specific situation. If you're exercising newly recognized gun rights, document everything and consult with an attorney if you encounter resistance from state officials. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these court decision updates first. Click that subscribe button because when the next circuit court drops a similar ruling, you need to know immediately. Number 6, 1 gun per month purchase limits are unconstitutional. Virginia had a law limiting handgun purchases to 1 per month. The court struck it down, holding that limiting how often a person can exercise a constitutional right is impermissible unless narrowly tailored to prevent actual illegal activity. The court found no evidence that 1 gun per month limits reduce crime or gun trafficking. They're simply arbitrary restrictions on lawful purchases. You can now buy as many handguns as you want in Virginia and other Fourth Circuit states. Number 7, assault weapon feature tests are unconstitutional. Maryland's assault weapon ban used a 2-feature test. If a semi-automatic rifle had 2 or more prohibited features like a pistol grip and adjustable stock, it was banned. The court held this feature-based approach is arbitrary and not grounded in historical tradition. The decision doesn't strike down Maryland's assault weapon ban entirely because it's still being litigated on other grounds, but it eliminates the feature test method of defining assault weapons. This creates problems for every state using similar feature-based definitions. Number 8, license fees exceeding the actual administrative costs are unconstitutional. Several states charge $200 to $300 for carry permits or firearm licenses. The court ruled these fees are excessive and function as a tax on constitutional rights. Permit fees must now be limited to actual processing costs, typically $25 to $50. States cannot use licensing fees as a revenue source or as a way to make gun ownership prohibitively expensive. If you paid an excessive fee for a license in the past few years, you may be entitled to a partial refund. Gun rights organizations are exploring class action lawsuits to recover these unconstitutional fees. Number 9, red flag law protections were significantly strengthened. The court didn't strike down red flag laws entirely, but it imposed strict due process requirements. Ex parte orders can last no longer than 14 days. Full hearings must be held within that time frame, with the respondent present and represented by counsel. The burden of proof is clear and convincing evidence, not preponderance. These protections make red flag laws much harder to abuse. If you're subject to a red flag order in a Fourth Circuit state, you now have much stronger procedural protections. Number 10, permitless concealed carry must be recognized for out-of-state residents. West Virginia and Virginia recently passed constitutional carry laws. The court held that these states must recognize out-of-state residents' rights to carry concealed without a permit on the same terms as residents. This creates a form of constitutional carry reciprocity. If you're visiting West Virginia or Virginia, you can carry concealed without a permit just like residents can, regardless of where you're from. Here's why the media is ignoring this ruling. This Fourth Circuit decision dismantles gun control measures anti-gun advocates spent decades building. Magazine limits, good cause requirements, training mandates, gun-free zones, feature tests, excessive fees, all gone in 5 states and vulnerable everywhere else. The media can't acknowledge this without admitting courts are systematically rejecting gun control when forced to apply actual constitutional analysis. So they're hoping you don't hear about it. Gun rights organizations are mobilizing. They're filing lawsuits in the 2nd, 3rd, 7th, and 9th circuits, using this Fourth Circuit decision as precedent. Within 12 months, similar rulings could expand these protections nationwide. Here's your action plan based on this court decision. Action step 1. If you live in Maryland, Virginia, West Virginia, North Carolina, or South Carolina, verify the current status of these laws. Check your state attorney general's website for guidance on compliance. Action step 2. If you were previously denied a carry permit, had restrictions on magazines, or faced other limitations addressed in this ruling, consider reapplying or exercising your newly recognized rights. Action step 3. Document everything. If state officials try to enforce invalidated laws, keep records of any resistance you encounter. This documentation will be valuable for attorneys challenging continued enforcement. Action step 4. If you live outside the Fourth Circuit, support gun rights organizations filing similar challenges in your circuit. These cases cost money, and your donations fund the litigation. Action step 5. Stay informed about implementation. Court decisions don't enforce themselves. Some state officials will resist, create new barriers, or slow walk compliance. Know your rights and be ready to assert them. Here's the bottom line. The Fourth Circuit just invalidated 10 categories of gun control laws across 5 states. Magazine limits, good cause requirements, extended waiting periods, overbroad gun-free zones, mandatory training, purchase limits, feature tests, excessive fees, weak red flag protections, and non-recognition of out-of-state carry are all unconstitutional in the Fourth Circuit. This affects 23 million people across 5 states. It creates precedent for challenges in every other state with similar laws. And the mainstream media is silent because they don't want gun owners to know their rights are expanding. But You have to exercise these rights. If Maryland gun owners don't buy standard magazines, don't apply for carry permits, don't push back on unconstitutional enforcement, the victory is hollow. Rights not exercised are rights surrendered. Look, I spend hours every week tracking federal court decisions, analyzing their implications, and breaking through media blackouts to bring you accurate information. The least you can do is hit that subscribe button. Subscribe right now. Share this video with every gun owner in Maryland, Virginia, West Virginia, North Carolina, and South Carolina. Most of them have no idea their gun rights just expanded. This is educational information about the Fourth Circuit Court of Appeals decision. It is not legal advice. Always verify current law and consult with an attorney before making legal decisions. 10 gun laws just changed and the media won't tell you. Now you know. Exercise your rights. Thanks for watching.